Thank you for attending this Seacrest Wordle webinar. My name is Amanda Fopma, and I am one of the partners in the Grand Rapids office of Seacrest Wordle, where a large amount of my practice is devoted to defending insurance carriers relative to property and casualty claims. Today we are going to discuss an emerging trend in the adjustment of total losses to property. Specifically, when does an insurance carrier owe replacement cost, but the insured has no obligation to actually replace the lost or damaged property? Recently, there has been a shift from what we all knew was the general rule, that an insurer had no obligation to pay more than the actual cash value of the lost or damaged property until repair or replacement had been completed and proof of the replacement cost expenses had been provided to the carrier. In exploring this emerging issue, we will look at the statutory sections, the relevant case law, and standard foreign policy provisions. Oftentimes, when a new property loss is reported, the first priority for an adjuster after determining whether there are any injuries are the basic facts of the loss: the type of loss, the date of loss, the type of claims, and establishing initial reserves. However, when a loss is reported, especially when there are several losses as a result of a significant weather event, how many times do you as adjusters look at the actual language of the policy form and endorsements before you conduct your site inspection? The emerging trend we are seeing is more recently there is an increase in the number of claims, especially in litigation, where the insured is arguing they are entitled to claim and receive a settlement of the full policy limit for a total loss to a dwelling without regard for the general requirement that the insured receives no more than the actual cash value of the lost or damaged property until actual repair or replacement has been completed and proof of the replacement cost expenditures have been provided. The main question with this emerging trend is, why do insureds and public adjusters believe they are entitled to hundreds of thousands of dollars when they may have absolutely no intention on replacing the dwelling? The answer is MCL 500.2827 and the case CORTEZ versus Fire Insurance Exchange. Let's first begin by looking at the Insurance Code of 1956 and the relevant statutory provisions. The Insurance Code of 1956 provides for two types of fire insurance policies. First, MCL 500.2826 discusses replacement of like size, kind, and quality of the damaged or lost property, while MCL 500.2827 discusses replacement or repair of the lost or damaged property with equivalent construction for equivalent use. The term equivalent can also be seen as like or similar. First, let's explore MCL 500.2826, liability for difference between actual cash value of property and amount expended to repair, rebuild, or replace. MCL 500.2826 provides an insurer may issue a fire insurance policy insuring property by which the insurer agrees to reimburse and indemnify the insured for the difference between the actual cash value of the insured property at the time any loss or damage occurs and the amount actually expended to repair, rebuild, or replace with new materials of like size, kind, and quality, but not to exceed the amount of liability covered by the fire policy. A fire policy issued pursuant to this section may provide that there shall be no liability by the insurer to pay the amount specified in the policy, specifically the limit of liability, unless the property damaged is actually repaired, rebuilt, or replaced at the same or another site. Turning to MCL 500.2827, subsection 1, fire policy providing reimbursement for loss or damaged property, maximum liability, cash settlement, payment of amount in excess of actual cash value of loss or damaged property. MCL 500.2827 subsection 1 provides an insurer may issue a fire policy insuring property by which the insurer agrees to reimburse and indemnify the insured for the difference between the actual cash value of the lost or damaged insured property at the time of the loss or damage. At this point, note that this first portion of MCL 500.2827 subsection 1 mirrors MCL 500.2826. It continues to state, the amount actually necessary to repair, rebuild, or replace the lost or damaged insured property to a condition and appearance similar to that which existed at the time of the loss or damage based on the use of conventional materials and construction methods which are currently available without extraordinary expense. The insurer's liability shall not exceed the amount of liability covered by the contract of insurance. The main distinction in the wording of MCL 500.2826 and 500.2827 subsection 1 is the provision discussing the type and nature of materials necessary for the repair or replacement. In that MCL 500.2826 requires the use of like, kind, and quality, while MCL 500.2827 subsection 1 requires repair or replacement with similar or equivalent construction for equivalent use. At this point, it would seem that the two types of policies are fairly similar. However, MCL 500.2827 subsection 3 provides in relevant part, a contract of insurance established pursuant to subsection 1 may provide there shall be no liability on the part of an insurer to pay an amount in excess of the actual cash value of the lost or damaged insured property at the time of the loss or damage, unless the lost or damaged property is actually repaired, rebuilt, or replaced at the same or another contiguous site. You will note that this language is almost identical to that which appears in the body of MCL 500.2826. The relevant and distinguishing language is contained in the last sentence of subsection 3. Specifically, this subsection shall not apply if the amount of loss or damage to the insured property under the standards of subsection 1 exceeds the limit of liability covered by the contract. The main distinction between MCL 500.2826 and MCL 500.2827 subsection 3 is a subtle distinction, but the impact is of significant import. Perhaps more importantly, the subtle distinction is one that has been routinely upheld against challenge. In continuing to explore this emerging trends, let's look at the basic policy forms and endorsements, and whether they truly are condition precedents to coverage. There are two standard loss settlement provisions in a typical homeowner's policy form. Replacement of lost or damaged property with like size, kind, and quality. Think of replacement of what they had the day before the loss with essentially what they had. This usually carries a higher premium, and when you think of repairs or replacements, under Section 2826, think of those 100 to 150-year-old mansions with plaster frescoes, solid wood, hand-carved ornate doors, and marble from a quarry that no longer exists. Under MCL 500.2826, the insured is required to replace the plaster frescoes with plaster frescoes and solid wood hand-carved ornate doors with the same. Because of the expense involved, the insurer is permitted to withhold payment above and beyond the actual cash value until replacement has actually been completed. The second standard loss settlement provision is replacement of the lost or damaged property to a condition and appearance similar to what existed at the time of the loss. Think replacement with equivalent or similar construction for equivalent or similar use. When thinking about a loss under Section 2827, think of a subdivision of starter homes where all of the homes have the same interior furnishings. A total fire loss occurs and the cabinetry in the home, which was purchased at big box retailer A, is discontinued. Under MCL 500.2827, subsection 1, the cabinetry can be replaced from big box retailer B because subsection 1 only requires repair or replacement with equivalent or similar construction for similar use. So if you are reviewing a policy and the language of the policy uses the phrase replacement with similar or equivalent construction for the similar or equivalent use, you have a policy that is subject to MCL 500.2827. Therefore, under subsection 3, the operative and important language is the last sentence, which states subsection 1 shall not apply, thereby entitling an insured, theoretically, to the total limit of liability under the policy without the need to actually repair or replace. Here is a typical policy form using the language for like size, kind, and quality. Under the loss settlement provisions, if the limit of liability on the damaged building is at least 80% of its replacement cost, commonly known as coinsurance, at the time of the loss, the carrier will pay the smallest of the following: the limit that applies to the building, the cost to repair or replace the damage on the same premises using material of like kind and quality to the extent practical, or the amount spent to repair or replace the damage. This policy language is consistent with MCL 500.2826. Now let's look at the standard policy form under the loss settlement provisions for equivalent construction for equivalent use, which provides that buildings and other structures under coverage A or B at replacement cost without deduction for depreciation, but not more than the least of the following amounts: replacement cost of that part of the building or other structure damaged for like construction and use on the same premises, or the amount necessarily actually spent to repair or replace the damaged building or other structure. But note, the standard policy form provides the carrier will pay no more than the actual cash value of the damage until actual repair or replacement is complete. Once actual repair or replacement is complete, the carrier will settle the loss in accordance with the provisions of the loss settlement above. While this standard form policy is consistent with the language required by MCL 500.2827, it still contains a provision indicating the insurer has no obligation to pay more than the actual cash value of the damaged or lost property until actual replacement or repair has been completed. So the question becomes, why are plaintiffs' attorneys as well as public adjusters pushing for the payment of full replacement cost without complying with the actual condition precedents set forth in the loss settlement provisions? Specifically, why are they requesting payment of the full replacement cost value without complying with the requirement that they do not get anything above and beyond actual cash value until the actual repair or replacement has been completed? The answer is simple. CORTEZ versus Fire Insurance Exchange, which was a 1992 Michigan Court of Appeals case. This is a primary case you will see plaintiffs and their public adjusters citing in support of their claims for policy limits without the need to repair, rebuild, or replace. The opinion of CORTEZ versus Fire Insurance Exchange is, in all actuality, a very short opinion with minimal facts set forth therein. The policy provided a limit of liability for loss or damage up to $36,000. The insured asserted the actual cash value of the dwelling, which was a total loss, was in excess of $35,000. The insured denied the claim on the insured's basis to file a proof of loss, which was a condition precedent under the policy. The insured then paid the mortgage holder $16,000 under the mortgage clause. The insurer claimed the insured was not entitled to the payment because they did not repair or replace, as required by the specific terms and conditions of the policy. The insurer claimed entitlement to the remaining $20,000 policy limit on the basis they could not repair or replace without the insurer's cooperation and payment. In reality, the insurer claimed the insured was not entitled to the remaining $20,000 because they had not actually repaired, rebuilt, or replaced, which was a condition precedent under the policy. The insurer was making the claim the policy was consistent with MCL 500.2826. On the other hand, the insured argued the policy provided for replacement with equivalent construction and thus was subject to the language of MCL 500.2827 subsection 3, and therefore there was no need for the insured to actually replace the property in order to be issued the remaining policy limits. The jury ultimately awarded the insured $20,000, finding the policy was in fact consistent with MCL 500.2827. The Court of Appeals, in issuing its ruling upholding the trial court's decision, held Section 2827, unlike Section 2826, contains a subsection limiting the insurer's ability to withhold replacement cost benefits until repairs have been made, where the amount of loss or damage to the insured property exceeds the amount of liability covered by the contract. There is no dispute in this case that the replacement cost of the insured's damaged property exceeded the $36,000 contractual limit of liability. Therefore, the Court of Appeals found pursuant to MCL 500.2827 subsection 3, the insurer was not authorized to withhold the insured's replacement cost benefits on the basis they had not actually repaired or replaced the property. Even though it is common to find policy forms which require replacement with equivalent construction for equivalent use, but later dictates that the insurer shall pay no more than actual cash value unless and until actual repair or replacement occurs, the question becomes, how do we reconcile this with MCL 500.2827 subsection 3? The answer are endorsements that increase the limit of liability, such as an increased cost endorsement or a guaranteed home replacement endorsement. By way of example, let's look at a sample extended replacement cost for coverage A endorsement, which states if there is a covered loss to the dwelling that exceeds coverage A's limit of liability shown in the declarations, For the purpose of settling that loss only, we will provide an extra amount of insurance up to 100% of the Coverage A limit of liability. The effect of this endorsement is simple. Given the limit of liability can be effectively doubled, and nearly all homeowners' policies require or have a co-insurance provision that requires the limit of liability be consistent with at least 80% of replacement cost, it is likely the total replacement cost value will not be in excess of the adjusted policy limits, thereby removing MCL 500-2827 subsection 3 from the equation. The question now becomes, why is it important to know from the outset of the adjustment phase if the policy and/or its endorsements are subject to MCL 500.2827 subsection 3? First and foremost, it's necessary to determine if the policy is in fact subject to subsection 3 to establish appropriate reserves. Additionally, it's helpful to get counsel involved early if there are concerns of fraud, and for the early development of a defense strategy if it's believed this case will go into litigation. And if it's believed that there will be a disagreement as to the amount of loss, it's important to develop an appraisal strategy. One of the first things an adjuster is tasked with doing after inspecting a loss, especially a total loss, is establishing the appropriate reserves. Many times an insured will let you know they intend to rebuild at the outset, especially if the lost or damaged property is their principal dwelling. So if there is anything that will increase the limit of liability, that must be known from the outset. Always remind the insured of their obligations in the event of a total loss, including that the insurer will only issue the actual cash value payment unless and until the repairs have been completed, and the most the insurer is obligated to pay under any circumstances is the limit of liability set forth in the declarations. If the policy provides for equivalent construction for equivalent use, recognize that the reserves are likely going to be higher depending on the age of the home. Do not be afraid to get counsel involved early on. In terms of appraisal, it is not uncommon for you and an insured to disagree as to the amount of loss and what it will cost to rebuild or replace the lost or damaged dwelling. If the insured has retained a public adjuster, bear in mind the public adjuster has a vested interest in developing as high of a replacement cost estimate as he or she can, which often results from taking a minimal depreciation and only one method to calculate the actual cash value and replacement cost value. Therefore, it's important for the adjuster to choose a very experienced appraiser who will utilize the broad evidence approach for establishing actual cash value and replacement cost value, and will take a stand during the appraisal process. You also need to ensure that your appraiser understands that any appraisal award needs to come in below the limit of liability, whether it's the limit of liability stated on the declarations page or adjusted by virtue of an increased cost endorsement or a guaranteed home replacement endorsement. Further, always ask your appraiser to ensure the actual appraisal award indicates it remains subject to all of the terms and conditions of the policy, including the replacement cost conditions. Recently, the question has become, does MCL 500.2827 subsection 3 apply only to a dwelling? The language of the loss settlement provisions, MCL 500.2826, MCL 500.2827, as well as CORTEZ and its progeny, all speak in terms of loss or damage, but do not limit the loss or damage to the dwelling. Hence, our firm is now seeing the argument since the insured has personal property replacement cost endorsement with their policy, which, depending on the policy, may permit the insured to replace damaged personal property with that of equivalent or similar personal property, they should be entitled to the full limit of liability without providing any proof they actually replaced those items of personal property. To date, whether any of these statutory provisions or CORTEZ apply to personal property has not been determined by the Michigan courts. There are some final considerations. Remember, when you are evaluating a loss from either an SIU or an adjustment standpoint, being cognizant of the policy form and endorsements and what it states in terms of loss settlement is vitally important. If the policy or endorsements, which supersede the policy form, indicates replacement with equivalent or similar construction for equivalent or similar use, MCL 500.2827 will likely apply, and the insured may be entitled to receive a settlement for the full limit of liability without having an obligation to actually replace the dwelling. Remember, it's important to make clear to the insured the insurer has no obligation to pay more than the limit of liability. And if something doesn't seem right about the loss, conduct a thorough investigation, being cognizant of potential financial and other motivations. If you have any questions regarding the contents of this webinar, please do not hesitate to contact me. Thank you for attending this webinar on ACV versus RCV when we owe replacement costs but the insured has not replaced. I look forward to hearing your questions and comments. Thank you.